There's Peter. Okay. Hi, everybody. Welcome to the February meeting of the PRC. Again, as I just mentioned briefly, we have a fair number of regrets, and I'll go through them now. Rob has a death in the family, unfortunately, so he can't attend, but he did send us his SECU report that I'll read into the record in a few minutes. Matthew is on holidays, the lucky dog. Brendan, this is good for him, not so much for us. He's been seconded to a parliamentary committee, and he'll be doing that from now until the end of the year. And they've advised Brendan that he should step back from the duties of the PRC because they believe that there may be some conflict in that we may, be making representations to members of that committee going forward. So he's regretfully stepped back and paused his involvement for the next 10 months or so. So there we go. Sarah can't make it. She actually has an injury that she has to attend to, so that's unfortunate. So we wish her well, and we'll see her hopefully next month. And Howard sent his regrets as well. All right, so there we go. So the next item of business, can I have a motion to approve the agenda as circulated? Michelle, seconder, Peter. Okay, all in favor? Thank you very much. Okay, so news items. I just posted a couple that are relevant lately. Not that we're going to do anything about them at this point, but the first item, of course, is the police corruption that has been, has been reported with respect to most particularly the Toronto Police Service, but it's also involved Peel. I don't know if it's involved any other services or not, but it's fairly widespread and incredibly disturbing with respect to the depth of the corruption that we're seeing. So that's a news item. Anybody have anything they want to contribute to that item?
Just that the Inspector General announced, it was either today or yesterday. I saw it this morning, but I think it was yesterday when he actually announced it. It's going to cover all 44 or 45 police services, including the Indigenous Police Service as well. So it's a really broad examination in that area. And quite frankly, it's probably I just finished reading the Inspector General's comments about undertaking this, and it gives me some pleasure to think that actually they may have not nipped it in the bud, but at least are fully addressing it in a very transparent manner, and hopefully it will be a better inquiry than the Nova Scotia mass casualty was. But that being said, I think it's a great step forward.
Excellent. Thanks, Peter. Any indication how long the Inspector General plans to take?
I didn't see, I haven't read anything at all, but I've been trying to follow it. I haven't seen anything about that at all. Obviously, it won't be just the individual doing it. There'll be a team under him, obviously. So I would suspect it's going to be minimum of a year, if not a little bit longer. To make sure that it's properly done. That would just be my speculation. I have no evidence to back that up.
Okay. Thanks, Peter. Anybody else? All right. We'll keep an eye on that. The second item I reported on the agenda was the shifting of the parliamentary committee, basically leaving behind for the time being the work on Bill C9, the hate crime legislation, and prioritizing moving forward with Bill C14. And I'll have a few comments on that when we get to that part of our agenda. Okay. Any other news or announcements anybody would like to bring to our attention?
Just that Premier Smith is still poking the bear, so to speak, with respect to appointment of judges, funding of judges, getting into a major discussion contest with judges, etc. And it's not going over very well in the legal community in Alberta. That part is for sure. And it's another. I think personally, it's one more attempt at let's get rid of the separatism bit for now. That's a bit rough for me. Let's go back to judges, and it's sort of management by deflection.
Yeah, I agree with that, Peter. And again, it's incredibly unsound constitutionally, but
Okay.
that doesn't really matter a lot to the premier. So
Yeah.
yeah, I agree. Thank you. Anything else, guys? All right, let's move on to business arising, the updates on parliamentary committees. This is going to be relatively brief because we're missing some folks. Again, we can't do the Justice and Human Rights for the Commons because Sarah is away. Rob is away, as I mentioned, but he did provide me with his a report that I'll read into the record, and here's what it is. SECU met 3 times since our last PRC on January 27th, February the 3rd, and the 5th. All 3 meetings were regarding Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments thereto. The main subject of discussion at the January 27th meeting was the new powers to be given to the Minister of Industry around the ability of that minister to issue urgent direction to companies in regards to protection of cybersecurity infrastructure, which, in my opinion, which is Rob's, would have no relevance to the work of the PRC. The written record of the other 2 meetings, also regarding Bill C-8, was not available on the SECU website as of this morning, but Rob suspects the discussions at those meetings would also be of minimal direct interest to us. If anyone has any questions or concerns, Rob indicates, please feel free to contact him. All right. We don't have a Senate committee report on legal and constitutional affairs. That's Brendan's. And when Brendan sent me his note, it was actually yesterday. Stepping back, he just basically said that everything stops as of yesterday. So unfortunately, whatever report, if he had prepared one, is not available to us. So I'll be looking to see if I can twist somebody's arm to take Brendan's place. So I'll send out an email after this meeting. And Senate and Human Rights, is Dick here? I don't see him. All right. So Dick's not here to present that. Oh, hang on. He's in the waiting room. So I apologize. Hi, Dick. I hope I didn't keep you in the waiting room too long. I didn't look up at that on that part of my screen. We've actually got to the point in the agenda for Business Arising where we're talking about parliamentary committees, and we're at yours. So the Senate Committee on
Oh,
Human Rights.
okay. For some reason, I can't get the video to work today, so you'll just hear my voice, I guess.
Okay. Thank you.
There's that much to report. The Committee on Human Rights is now studying employment equity in the federal public service, and it didn't seem particularly relevant to our committee.
Okay. Is that the report?
That's it.
All right. Thanks, Dick. We have no questions, obviously, on that, so thank you very much. Other items of business arising. The next item that would have been on the agenda if Sarah was here was the position paper that she and Michelle prepared regarding AI and justice. And so we'll wait for Sarah's return next to our next meeting, and hopefully Michelle's there as well. And then we'll touch on that when
Can
she
I say a
returns.
word nonetheless, Miles?
I'm sorry,
Can I
Michelle?
say a word? So we didn't get a whole lot of, I don't know that we got any comments about what we were circulating as a draft, but I'd like to wrap this thing up before the next meeting with Sarah. And what I'd like to do, if there are no other comments, I would get Nancy to edit the document and propose to have it printed in the justice report kind of thing.
Well, all right. I did receive some comments directly that I was going to, discuss if Sarah was here. So if that's what you want to do, Michelle, that's fine. Put together what you and Sarah want to finalize. Send it to me if you wouldn't mind. I'll
Okay.
get back to you with the comments I have to date, and we'll take it from there.
Okay, and we will possibly contact Nancy afterwards.
Well, that's if you want to produce it in the justice report.
Well, we'd like to have it printed somewhere.
Okay, well,
And
listen,
if the PRC is not interested, and the justice report is not the right, Sarah spent a lot of time reading that stuff. I did too. I don't want it to just disappear, And
Oh, absolutely. These things take a lot of work, and we acknowledge that, and thank you for that. Yeah. Whenever you're talking to Sarah, you're welcome to get a hold of me, and we'll
figure it out.
we'll talk about next steps once you guys are in a final position to go forward.
Sounds good.
Yeah. Thank you,
you.
Michelle. Good stuff.
Miles?
Yes.
Um, I suppose I've received the paper, but I haven't read it. I've wanted to read it. Could you tell me when it was sent and by whom, or just send me another copy? I think
Yeah.
it's likely I'll have some comments, particularly regarding risk assessment.
Okay, Dick, leave it with me. I will send you a copy of the paper.
Okay,
It's a
thanks.
position paper.
Thanks.
No problem at all. Okay, I can tell you that I didn't highlight it because it only came to my attention yesterday afternoon. This is regarding the Miscarriage of Justice Review Commission, which is sub-item F. I I talked to my contact on the Justice Committee, and he talked to the minister, and this is actually good news. The minister indicated that he was reviewing his short list to appoint the head commissioner, and that will be done shortly. And that's the next step, the next natural step. Once the head commissioner is in place, and that's a position, that's a full-time position, who will be situated in Winnipeg, which is where the legislation requires the new head office to be. Once that position is filled, then the Privy Council will be posting notices to fill the remaining commissioner positions, which will be a combination of full and part-time commissioners, and anywhere between 5 and 8, because 9 is the upper limit, and the ninth position is the lead commissioner. All right, so that's great. That's good news. So obviously it's not dormant. It is going forward. It's an internal thing with the Department of Justice at this point, but that or the ministry, and that's perfectly fine. So hopefully we'll have something more to report for the next meeting, which will be the actual appointment of the commissioner, and then off we go. So I'll keep everybody up to date when I hear something more. Okay, the next item I want to talk to is sub-item I, which is death in custody, the coroner's report. We have nothing to add for that. There is no report generated, and we have Andrea's name attached and Matthew's attached to that. So we're going to drop that or remove that from the agenda. So that'll be deleted from the next agenda for our next meeting. Next on sub-item K, this actually has some relevance today because I think that Martin is here with us. So hi, Martin. Glad to have you here. This is with respect to Ontario legislation, which it's unusual for us to do provincial, but we're doing it in this case, which is Bill 75. This is the bill that we've talked about in the last couple of meetings with respect to requiring cash deposits that go with sureties on a bail application. We decided that we wanted to have a brief prepared, and so Martin did that for us, and I've circulated it to everybody. So you've had a chance to take a look at it. I think it's an excellent brief. There was a couple of small amendments I asked Martin to incorporate when he put it together, and he did that for us. So I want to get some comments or responses from anybody who has taken a look at the brief, because the next step would be to submit it to the Ontario Legislature, or at least the Justice Committee, when it actually is going to hold meetings and delegations on this bill. Anybody have any comments for Martin on this brief?
I do.
Okay.
I agree with you, Miles. I think it's an excellent brief. It's very well done. And I have nothing to add other than when I was working on my bail reform paper, doing the research on it, one thing that struck me was that, and I did not include it in the paper, was that the United States as you may know, there's basically a movement in the United States away from cash bail, and they actually prefer what has been the Canadian model. So if you wanted to throw that in, I could get you some. I could probably dig out the citations for them for where I found that view. But anyway, it's Canada's going, or Ontario, I should say, is going in the opposite direction. And I know the U.S. isn't much of an example, but here's one where they were trying to follow a Canadian example, and now Ontario is going in the old U.S. direction. But other than that, I thought it was a good brief, very good brief.
Yeah, thanks, Dick. I mean, that's a good reference, and if you could send that to Martin, Martin, please take a look at it and see if you can insert it somewhere in the brief. That's further information that is worthwhile. And Martin, I think his hand just went up there. So,
Oh, yes. Sorry, I can't turn my camera off. Yeah, it was just a quick comment that I think that would be a good point to add on the U.S. It would be appreciated. I read a bit about their model and how, in fact, it's a whole secondary industry. There's a private industry around it in certain states in terms of the catch bail and the loans. So it would be very appreciated.
Yeah, thanks, Martin. Well, we've got you. I mean, for the purposes of everybody who's here, and for those who are going to watch this video once I publish it, maybe you just can give us a quick overview of your brief.
Yes, absolutely. Let me just open it up quickly. Just an overview on the bill itself. It's Ontario Bill 75. It's made up of 7 schedules, which range from like the Animal Protection Act to other reforms, but the brief focuses specifically on Schedule 2, and more specifically on the measure to require cash security deposit in the full amount once the accused person is released on bail, or also for sureties. So it would be essentially a condition for bail to deposit all the money up front. In terms of the arguments, the 3 main ones. The first one, and perhaps the most clear one, is the constitutionality of it. Within sort of our constitution and how it's outlined, the province is only responsible for the administration of justice as opposed to procedure. And Section 515 of the Criminal Code already sort of covers all the conditions around bail and how it ought to be administered by the province. But even further, sort of in Supreme Court precedent, there are already guidelines on how bail should be administered, and that, sort of in short, that jurisprudence goes against the principle of something like a cash deposit. Otherwise, so that's the first argument. The second one is more on the proposal itself and its effect on how severe it can be for the accused. Of course, the idea that it's a big financial burden and creates sort of a two-tiered system of justice, where legal merit isn't as heavy as simply being able to produce the capital to receive bail. And then finally, sort of the more practical implications, sort of linking back to the province's responsibility province's jurisdiction on administration of justice, and the idea that there's already a very big problem with overflowing and overuse of detention as well. Sorry, I'm just going through the brief if I'm missing anything, but essentially, the already high proportion of people who are legally innocent but incarcerated, and the idea that this measure would simply contribute to that overcrowding. And paradoxically, in many cases, overcrowding has led to not only complaints, but complaints that have directly resulted in stayed proceedings and reduced sentences. So in a way, it actually creates the possibility that someone accused of a crime could have their sentences reduced because going into an overcrowded environment could result in abuses or in complaints. So, and finally, just the idea that there is no empirical evidence around it. I think, of course, the U.S. angle could be useful because it's a place where it has already been implemented, and we can sort of see some studies are cited in the brief on how there is no solid empirical evidence to suggest that it would create a deterrence against violating bail conditions, but. I think that's. I hope I summed it up properly. I think on the recommendation front, they're pending still, so any feedback or input on that would be useful as well. I saw a lot of people who opposed this measure were advocating for sort of supervised bail and reducing the burden on sureties to begin with. as just as a side note, this bill also wants to increase the powers of the province to seize property from sureties if they cannot produce amounts that were promised. So sort of a bit of context there, but yeah, I think that sums it up.
Thanks, Martin. That's excellent. Subject to the recommendation by Dick and any other comments anybody may have, my recommendation is that this brief be prepared and that we present it to the Justice Committee after it gets to its finished with its debates. The last debate was in December, which was adjourned, so it hasn't moved to committee yet. But once it does move to committee, just like the House of Commons, we can basically make a request that we have a delegation. So I'd be more than pleased to go with you, Martin, and we'll go to Queen's Park and make that delegation. If anybody else wants to join us, you're absolutely welcome to do so. I just put that recommendation out there just to see if that is agreeable to the group.
Sounds good.
Yep, we have nods. Good, thank you. Okay, Martin, that's great. Again, appreciate it very much. And I'll bring your synopsis to the attention of everybody when I send the video out of today's meeting. Okay, that's it for business arising. So
sorry to interject. Just I wanted to, I may have missed this, just how it works for like any amendments or sort of recommendations. Is that something that'll be done sort of offline? Of course, I'll be looking maybe to integrate that part on the US once information comes in, but more specific, like do we always have recommendations or is that more fluid and maybe it's not something we'll have, or yeah, just process on that. I'm fairly new to it.
No, I mean the only recommendation. I mean, it's pretty clear that everybody is going to adopt it. It's we everybody accepts it. Nobody has anything to say that it's not going to go forward. So I think we accept it. And although I should say, and it's my fault. I think once you've made the final addition based on Dick's comments, we'll send it to the board. And I should have said that before. So we'll send it to the board for their review, and then based upon their recommendation to go forward, then we'll prepare a delegation. Does that sound right?
Yeah. Oh, sorry. I'll let Irving go.
No, I'm not sure, Mark, if you're asking whether there should be a recommendation after the conclusions.
Yes. That was mostly, I mean, of course, it's very useful to know how it works as well, like with the board, but also just the recommendation in the brief itself. Because I noticed that sometimes we'll include sort of the final part will be more like sort of formal list of things that, well, sort of what we were asking the committee to do. Sort of what, yeah. So
well, I think in this case, we're basically going to recommend that they drop the bill.
Or I guess the schedule, yeah, like part of it. But okay. I guess if there are any comments on that as well, would be appreciated. But I'll write that down.
Yeah, sorry, I'm gonna jump in. Like, might we want to consider recommendations to the committee? So if it's all or nothing, but then if they're looking for ways to tweak the bill, recommendations around more supervised bail, alternatives to supervised bail in the community, for example, instead of just like cash bail and remand, or is that what you're getting at, Martin? Are there other like recommendations that we
Yes, exactly. So supervised bail was the first one that came to mind, but I didn't add it because I wasn't sure, sort of like I didn't want to misrepresent the sort of the views of the PRC or anyway. But I think that, of course, like repealing that section of the act, and yeah, maybe relief measures such as supervised bail. But if I guess it's open to any other kind of alternatives that we want to add.
Yeah, or even off the top of my head, I'm thinking things like additional funding for the completion of pre-sentence reports and things like that would help reduce time that people are spending on remand.
Yes, okay, I'm writing this down.
Yeah, so maybe what the thing to do then, Martin, is make some recommendations, and then when I send it to the board, I'll ask for the board's input on those recommendations, those that they would support or not support necessarily, which would then be part of the final product. I think that makes sense.
By the way,
Yes, that makes
Miles,
sense.
oh, pardon. Go ahead, Mark.
Oh, no, sorry. I just wanted to say it makes sense. I was muted, but thank you.
Yep.
I connected with our affiliate, CJAO, and they were more than hesitant to get involved because of potential conflict of interest. Many of them are with the AG, so you know they don't want to get into trouble with their employer. I can understand that, right?
Gotcha. Thanks, Irving.
Anyway, Martin did a terrific job. Thanks, Martin.
Super. Thanks, guys. Anything else on this item? Okay, thank you. Bills under consideration. So there's only a couple that basically have anything of import that's happened since our last meeting. I can tell you, and this actually quite surprised me. At our last meeting with respect to Bill C-14, it hadn't moved into committee at that point, which is what we were talking about potentially appearing before the Justice Committee for when it accepted witnesses, and there was a few of us that were going to actually potentially go to Ottawa and do that. When I checked back with the committee this week to see about timing for that, they indicated that in fact the delegations are closed and they're moving into debate on sections of the bill. So they and this is part of the news thing that I guess I announced at the beginning of the meeting. They expedited the bill's passage. So they, in fact, whatever they did, they had very, very limited opportunity for delegations to appear to provide testimony on the bill. So in fact, that opportunity is gone. So I guess if I was following it every day, I maybe would have caught that, but I didn't. It usually doesn't happen that way. That basically they go from second reading and then they expedite the process for hearing delegations, going right to the debate on the sections of the bill. So for whatever purposes, that's no longer available to us. All right. So, but having said that, we know that, and this is the product of Dick's work on bill reform, that the Justice Committee has that in front of them already, and had it before the bill was introduced. Irving, you were going to say something?
No, I'm just adjusting my screen. Sorry.
Okay. All right. Yeah.
Miles, excuse me.
Sure.
This is Dick again.
Hey, Dick.
Are you sure that my paper has been submitted to this committee? Because the only one I remember was the Senate, I guess it was the Senate Justice Committee that was doing no, I'm wrong on that. It was House of Commons. Okay, I just wanted to confirm that they have received it.
That's my recollection, Dick, that they had received it. I remember I made a comment at the time because I thought that was somewhat unusual that they would receive that before they actually introduced the bill.
Yes, right.
But they had. Now, what they did with it, after the bill's introduction, I don't know. Again, we weren't given the opportunity, or we missed the opportunity to have a delegation before the Justice Committee with respect to your paper. And at this stage of the game, they're not accepting anything further from external sources. So, there would be no point in sending the paper again, Justice Committee, because that is done. Which I'm disappointed that the committee would rush that through. But as we saw in the news, it's a priority to now get this passed. It's part of the federal government's priorities to look like they're doing something about bail, and they're going to do what they're going to do. So our input is now at an end. But we can only take solace in knowing that the committee at some point had seen your paper, Dick, and hopefully paid some attention to it. We will see. All right. Any other comments or questions about that? Okay. All right. With respect to anything else, Bill C-16 has had second reading since our last meeting, and that's it for public and private bills in the Commons. And the only other bill that is of note is Bill S-205, which is a private members bill in the Senate. And I just want to make a note that at our last meeting, we talked about sending a letter to the Senate with respect to our position on the bill. And it has Andrea's name attached to it, but that didn't, and I want to make clear that doesn't necessarily mean that Andrea is doing the letter. It was just part of the discussion we had last meeting. So we are, I guess, still at the position where, and we decided to do this as a function of delegating our priorities based upon our last meeting. So are we still up for sending a letter to the Senate with respect to our position on S205? Andrew, what do you
I
think?
thought we were, I mean, it kind of rambled a bit last time. I was under the impression we're going to wait till it gets into the House of Commons because it's already gone through the committee structure, right, in the Senate?
I've got it down as having second reading on October 21st. I don't know whether it's finished its committee in the Senate.
I thought it had.
Well, I can check that.
Yeah.
Sure.
And the CBA sent in a pretty comprehensive letter, I guess, as well.
Right. I'm open to suggestions. I mean, depending on whether the committee is receiving any material or not, if it is or it isn't, what do we want to do?
I think it's still, well, one, I think first step is figure out where we are in the process and to determine where the letter goes. But I think we should be putting out a public statement. Like the whole discussion about this at the last meeting was we seem to be last on the bandwagon. There has already been joint statements and collaborative statements that have gone forward from other like-minded organizations such as ours, and we haven't taken a position on this. And so rather than putting together a full brief and trying to present, we were going to send a letter just identifying our support for the bill. So from my perspective, I think that's still important for us to do as an organization.
All right, why don't I draft? I'll draft something and circulate it, and if it's approved, then we'll send it off. Is that okay? Give it a shot.
That would be well appreciated, Miles. Thank you.
Sure, I'll do that. Yep. So let me do that. I'll do that, in the next day or two, send it around, and then see if we're going to forward it on or amend it, and then forward it on. We'll take it from there.
Okay.
Okay, good guys. And that's it. So there we go. There's nothing else in the bills that we're paying any attention to. Does anybody have anything else to add for our meeting for the purposes of everybody?
Miles, could you send me a copy of Rob's brief that he'd sent in to you that you read off? I'm just interested in the cybercrime piece that's on that.
Oh yeah, it's an email, so I'll forward you the email.
Yeah, that'd be perfect. Thank you so much.
Sure, let me go to that. All right, guys, anything else? Oh, all right. So, one more thing. So the next meeting is scheduled for March the 10th. I'm out of the country on March the 10th. Two options. We can either have somebody else run the meeting or push it over a week. I'm coming back on the 16th, so I'll be available for the meeting on the 17th. So whatever you guys want to do is that perfectly fine with me. So either someone else can run the meeting or we can push it over a week. What do you think?
Push it to the 17, Miles. I don't think anybody can take over from your role in this thing there.
All right, guys. Yeah, I'm fine with that. So I'll get back on the 16th, put it agenda together. So you get the agenda the same day of the meeting, likely, and I'll make a note of that. What's that?
The
17th?
17th, yes, yeah. So instead of the second.
Everybody's gonna have to dress in green there.
I was just going to say that.
That's fine. Yeah, I'll bring a leprechaun with me, and off we go.
Good stuff.
All right, guys. Thank you very much. Appreciate your attendance.
Thank you, Miles.
Thanks, Miles.
Have a good
Bye,
day.
everybody.
See you guys.
Right.
Bye-bye.
Take care.
See you. Bye-bye.
Bye.